preservation of and increased access to the 92nd Street Y Humanities Audio Archives is generously funded by the National Endowment for the Humanities.
We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Article 1, Section 1. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. Section 2. The House of Representatives shall be composed of members chosen every second year by the people of the several states, and the electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature. The House of Representatives shall choose their Speaker and other officers, and shall have the sole power of impeachment. Section 3. The Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature thereof for 6 years, and each senator shall have 1 vote. The Vice President of the United States shall be the President of the Senate, but shall have no vote unless they be equally divided. The Senate shall choose their other officers, and also a President pro tempore in the absence of the Vice President, or when he shall exercise the office of President of the United States. The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. Section 5. Each House may determine the rules of its proceedings, punish its members for disorderly behavior, and, with the concurrence of 2/3, expel a member. Section 8. The Congress shall have the power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States. To borrow money on the credit of the United States. To regulate commerce with foreign nations and among the several states, and with the Indian tribes. To establish an uniform rule of naturalization and uniform laws on the subject of bankruptcies throughout the United States. To coin money, regulate the value thereof and of foreign coin, and fix the standards of weights and measures. To provide for the punishment of counterfeiting the securities and current coin of the United States. To establish post offices and post roads. To promote the progress of science and useful arts by securing, for limited times to authors and inventors, the exclusive right to their respective writings and discoveries. To constitute tribunals inferior to the Supreme Court. To define and punish piracies and felonies committed on the high seas and offenses against the law of nations. To declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water. To raise and support armies, but no appropriation of money to that use shall be for a longer term than 2 years. To provide and maintain a navy. To make rules for the government and regulation of the land and naval forces. To provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. To provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively the appointment of the officers and the authority of the training of the militia according to the discipline prescribed by Congress. To exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square as may, by cession of particular states and the acceptance of Congress, become the seat of the government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings, and to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States, or in any department or officer thereof. Article 2, Section 1. The executive power shall be vested in a President of the United States of America. He shall hold his office during the term of 4 years, together with the Vice President, chosen for the same term. Before he enter on the execution of his office, he shall take the following oath or affirmation. I do solemnly swear or affirm that I will faithfully execute the office of President of the United States, and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. Section 2. The President shall be Commander-in-Chief of the Army and Navy of the United States, and of the militia of the several states, when called into the actual service of the United States. Article 3, Section 1. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. Section 2. The trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crimes shall have been committed. But when not committed within any state, the trial shall be at such places or place as the Congress may by law have directed. Article 4, Section 4. The United States shall guarantee to every state in this Union a republican form of government, and shall protect each of them against invasion, and on application of the legislature or of the executive when the legislature cannot be convened, against domestic violence. Article 5. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution. Article 6. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. But no religious test shall ever be required as a qualification to any office or public trust under the United States. Amendments to the Constitution. Amendment 1. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. Amendment 2. a well-regulated militia being necessary for the security of a free state, the right of the people to keep and bear arms shall not be infringed. Amendment 3. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. Amendment 4. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. Amendment 5. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without just compensation. Amendment 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the Senate and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of his accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Amendment 7. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. Amendment 8. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Amendment 9. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Amendment 10. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people.
Good evening. I'm Laura Kaminsky, Associate Director of Education, and it's my pleasure to welcome you to the 92nd Street Y for the first evening of our four-part series on the bicentennial of the Constitution. Our reader for the excerpts, which you just heard, is Eric Swanson, a 1981 Theater Studies graduate of Yale University with a 1985 degree from the Juilliard School Drama Center. Mr. Swanson's recent Broadway credits include You Never Can Tell. Off-Broadway, he has been seen in The Misanthrope and The Waltz of the Toreadors at the Roundabout Theater. Most recently, he has narrated Jerome Robbins' Fanfare for the New York City Ballet. This series is part of a major programming initiative at the 92nd Street Y to provide a forum for consideration of how our Constitution functions, how it has evolved, and what issues remain of concern to us today as the Constitution approaches its 200th birthday. Beyond this four-evening public lecture program, we are pleased to offer two courses in the Wise Humanities program. One titled The Perennially Endangered First Amendment, provides a unique opportunity for you to study critical issues such as national security, freedom of expression, and church-state relations with Nat Hentoff, the esteemed columnist for the Washington Post and the Village Voice. The second course, The Constitution Then and Now, is taught by Dr. Richard Pius of Columbia University and Barnard College, author of the masterful Presidents, Congress, and the Constitution. Information about these two special courses can be found in the next to last page of the program you received tonight. The 92nd Street Y is pleased to acknowledge Philip Morris Companies, Incorporated, which provided a generous grant in support of this series. An affiliated educational program is being made possible by the Albert A. List Foundation with the cooperation of the American Federation of Teachers. Now to the evening before us. Following Professor Morris's introductory statement, Benno Schmidt will present his lecture, Reflections on the Evolution of the Constitution. After the address, Professor Morris will engage President Schmidt in a conversation in which they will be able to discuss further some of the issues raised in the initial talk, as well as others which they both deem pertinent. The final segment of the evening provides you, our audience, an opportunity to submit your questions written on the index cards you received upon entering the hall. Once the conversation on stage is underway, ushers will come down the aisles, collect your cards, and bring them backstage for presentation. It is indeed an honor to be able to introduce series moderator Richard B. Morris, Governor Morris Professor of History Emeritus and editor of the papers of John Jay at Columbia University. He is past president of the American Historical Association and the Society of American Historians, and a trustee of the John Jay Homestead. He is author of numerous books in American history, including Government and Labor in Early America, the Bancroft Prize-winning The Peacemakers, and the Encyclopedia of American History. Now it's in its 6th edition. He is co-editor with Henry Steele Commager of the New American Nation series, a multi-volume re-examination of the history of the American people, and currently author of 2 books on the framing of the Constitution, Witnesses at the Creation, New American Library, and The Forging of the Union, Harper and Row, coming out in May 1987. He is co-chair with James McGregor Burns of Project 87, an organization jointly sponsored by the American Historical Association and the American Political Science Association to stimulate nationwide study and understanding of the Constitution. Please join me now in welcoming Richard B. Morris. Thank you.
Ladies and gentlemen, this series of symposia has 2 purposes. It provides occasion for celebration and cerebration. The Constitution of the United States is now fast approaching its 200th birthday. That great charter of governance still commands deep affection, even veneration, and with good reason. It has functioned and endured longer than any other written constitution of the modern era. It infuses the nation with energy to act, while at the same time placing restraints on its agents acting out of line. It safeguards our liberties and establishes a government of laws, not of men and women. It is a living, functioning reality touching every person's life, and the one surviving symbol of that exceptionalism, that freedom which America, by reason of location and resources, has historically enjoyed from old world castes, animosities, and tyrannies. Perhaps above all, the Constitution is the mortar that binds our 50-state edifice under the concept of federalism, the unifying symbol of a nation composed of some 250 million people claiming different origins, races, and religions. If the Constitution is venerated, Its functioning is still a mystery to the majority of the population, which shares only the vaguest notions of its text and performance. At the same time, it is an issue-laden document, one which finds the country sharply divided on its enforcement. Such divisions are not new. They existed almost from the beginning of the first national administration, when an opposition arose to insist upon a strict construction of the Constitution. Some came to urge that each state had the right to interpose to arrest the alleged evil of the federal government exceeding its delegated powers. Later, the right of a state to nullify an act of Congress was asserted. And finally, the insistence of some states of the right to secede from the Union brought on a civil war. That war settled the question. The Constitution was perpetual. No state could secede, while a series of revolutionary amendments were adopted ending slavery, and by later court decision extending the Bill of Rights from purely a restraint upon Congress to a prohibition on the states as well. Although the Constitution has been changed by amendment, judicial decisions, and precedents established by both the executive and the legislative branches of the government, numerous interest groups insist on further changes. They would have a balanced budget amendment, for example, and the nation is divided over issues of desegregation, the death penalty, abortion, privacy, and the role of religion in the schools. Others would enlarge the role of the states at the expense of the national government and reinterpret the Constitution according to what they understand to have been the original intent of the framers. Hence, the special timeliness of this series of symposia on the bicentennial of the Constitution, a series which aims to provide understanding of how our Constitution really works and to consider critical issues that its functioning raises, issues that have not by any means been resolved. To enlighten us about the Constitution and weigh the current divisive issues about that venerable document, these symposia have assembled a group of notable experts, some of whom have served with high distinction in government and others nationally recognized as scholars of the Constitution. There is a very special, if perhaps unintended, connection between our honored guest speaker this evening and the opening of the convention, of the Constitutional Convention at Philadelphia. In the spring of 1787, William Samuel Johnson, Yale class of 1744, before taking leave of his post as a Connecticut delegate to the Continental Congress, then sitting in New York, he took leave to attend the Grand Convention in Philadelphia. He took the oath of office as president of Columbia College, the old King's College, but now rechartered by the state legislature. In fact, this spring, two bicentennial celebrations are going on at the same time, Columbia's and the nation's Constitution. Now, William Samuel Johnson was a jurist of distinction. He played a key role in pushing through the so-called Connecticut Compromise, which, by giving each state, regardless of size, an equal vote in the Senate, satisfied the small states, provided a firm base for federalism, and explains why the small states, with two exceptions, ratified the Constitution so quickly. Johnson also served as chairman of the Committee on Style, which, in a few days, with the assistance of such superstars as Gouverneur Morris, James Madison, Alexander Hamilton, and Rufus King, wrote a blueprint in 4 manuscript pages, some of which you have just listened to, a blueprint that has endured with amendments to the present day and has established sovereignty in we the people. Tonight we have the same picture in reverse. A distinguished Columbia Law School professor of constitutional law, a foremost authority on the First Amendment and areas such as capital punishment, fair trial, free press, and presidential impeachment, co-author with the late Alexander Bickel of the volume in the history of the Supreme Court issued under the prestigious Oliver Wendell Holmes devise, Yale educated, like William Samuel Johnson, law clerk to Chief Justice Earl Warren, with a couple of years of service in the Department of Justice, a firm advocate of placing law in the setting of other disciplines, Benno Schmidt comes back to New York as president of Yale University and with specially demonstrated rare talents as a TV and movie star as well, all of which I'm sure we have seen. We welcome Benno Schmidt, who will give us the benefit of some of his reflections on the history and role of the Constitution. Benno Schmidt. Thank you. I think a little unusual.
Well, that first Columbia president was a good Yale man, concerned about some of the smaller states and head of the Committee on Style. Well, I am delighted to be back at the Y. I have enjoyed things here from Bach to basketball, with poetry readings and movies with Judy Christ somewhere in between. And I think of this as a small down payment on my debt of gratitude to this great cultural resource. I want to talk about the Constitution, and in particular, the uses, the necessity of historical perspective in constitutional interpretation. In 1819, in the course of the most important decision handed down by the Supreme Court in our first 200 years, John Marshall made, I think, the wisest, though far from the wittiest, statement ever uttered about the Constitution of the United States. The decision was McCulloch against Maryland, in which the Supreme Court upheld the constitutionality of the fiercely contested Second Bank of the United States and denied the power of the states to impose on one of the bank's branches a discriminatory tax. In considering this question, the great Chief Justice wrote, "We must never forget that it is a constitution we are expounding, a constitution intended to endure for ages to come, and consequently to be adapted to the various crises of human affairs." Why do I make the claim that this rather homely, even circular statement caught in a few words the highest wisdom about our Constitution? The statement has had some stiff competition over the years. Let me give you some examples. Very frequently cited in our century among great statements about the Constitution is the rather blunt remark made in this state by then Governor Charles Evans Hughes, a remark which incidentally dogged Mr. Hughes after he became Chief Justice. "We are under a Constitution," Hughes said, "but the Constitution is what the judges say it is." I imagine, on the other hand, that the favorite of the bicentennial oratory, which we are all in the process, to which we're all in the process of being subjected, will probably be the familiar statement of the great British statesman William Gladstone, namely, that the American Constitution is, so far as I can see, he said, the most wonderful work ever struck off at a given time by the brain and purpose of man. A mordant view had earlier been offered by another discerning Englishman, Thomas Babington Macaulay. He said to an American, "Your Constitution is all sail and no anchor." And while I'm at it, recalling great quotes, I cannot forbear putting before you Chief Justice Warren's favorite quote. On September 17th, 1787, the day the delegates rose in Philadelphia upon the signing of the Constitution, Benjamin Franklin was approached by a woman outside Independence Hall, and he was asked, "Well, doctor, what have we got? A republic or a monarchy?" And Franklin replied, "A republic, if you can keep it." Now, I hope you will not count me parochial if I defend the primacy of John Marshall's wisdom by insisting that his statement embodies what has been, is, and pray will be always and invariably the central truth about the Constitution, that it is law. Law in the grandest sweep that the human quest for justice has ever summoned up, and law in the nitty-gritty sense of controlling the police on the beat and providing rules of decision for the hearing officer in traffic court. Now, I readily agree, and would indeed want to insist, that our great constitutive act of law is far too important to be left to the lawyers. But before, or indeed after, the Constitution is an expression of political philosophy, and certainly after, if not necessarily before, the Constitution is an artifact of history or an expression of political purpose or compromise. It is law, first and finally. As such, its bicentennial celebration and cerebration invites us not only to an exercise of historical imagination about its origination, its 18th century context and connotation, but to present, ongoing duties, inescapable for citizens in a society of law, duties of interpretation of law and of current application of law, duties to see to it that the Constitution continues to adapt, to recur to Marshall, to the various crises of human affairs, and indeed, beyond that, to all the infinite range of relations between the citizen and the modern administrative state. Now, I want to reassure my old friend Dick Morris that all this talk about law does not mean that on this bicentennial occasion or on any other time that the Constitution comes up, that we can turn away from history. One of the favorite ellipses that I have always carried around in my head since my law school days, that I found then and now about equally profound and elusive, is the saying of one of my teachers that law is history with the history left out. Whatever that means, I am pretty sure applies especially to the Constitution of the United States. Now, if there is one thing that worrying about the Constitution for 2 decades has taught me, I know, Dick, that doesn't seem very long to you. When Vartan Gregorian asked me who should take the lead in organizing the New York Public's very fine bicentennial exhibition, it's well worth a visit, by the way, I responded, "Why, Dick Morris, without a doubt. You know, of course, that he is a good friend of John Jay's." And James Madison stops by to see him whenever he is in New York. In any event, Dick, if I have learned one lesson from working with the Constitution, it is that a historically grounded reading of the authoritative constitutional text must always be the foundation of constitutional interpretation, not necessarily the end of interpretation, but always the foundation. And this brings me to the general subject of my talk this evening. What can we ask, what should we ask of history in constitutional interpretation? And specifically that history which casts light on the original intention of the framers and ratifiers of the Constitution. What we can ask of history is a great deal, I would assert, so long as one approaches history with sophistication about political situations and intellectual context, with skepticism towards simple claims, with tolerance for ambiguity and for historical flux, and above all, with due weight, which is to say great weight, given to the constitutional text which the framers chose as the ultimate and authoritative vehicle for the expression of their intentions. And all of this always informed by the great lesson of John Marshall, that we must never forget that it is a constitution we are, and the framers were, expounding. Now, it will come as no news to this group that the role of history in constitutional interpretation is currently the subject of an extremely important controversy. An extreme view of this extremely important controversy has recently been put forward with great fanfare by the Attorney General of the United States, Edwin Meese III. Mr. Meese insists that any constitutional decision not directed by the specific original intention of the framers of the Constitution is illegitimate. And Mr. Meese has a very tight view of what this originally intended meaning is. I quote, "Those who framed the Constitution chose their words carefully. They debated at great length the most minute points. The language they chose meant something," close quote. Any approach to constitutional interpretation more creative than what Mr. Meese calls a jurisprudence of original intention must be, he asserts, and again I quote, "tainted by ideological predilection," close quote. Almost as if to shock his audience with the full sweep of his theory, Mr. Meese has questioned the 60-year-old process known as selective incorporation, by which most of the Bill of Rights provisions have been applied to limit the power of the states. Mr. Meese has suggested that this theory may be wrong because it was the framers' intention in 1791 that the Bill of Rights only limited the powers of the federal government. When he first advanced this rather startling proposition, Mr. Meese failed even to mention the post-Civil War 14th Amendment, which declares, among other things, that no state shall abridge the privileges and immunities of citizens of the United States, nor deprive any person of life, liberty, or property without due process of law. This is the provision that has been the textual basis for the theory of selective incorporation. For missing this link, Mr. Meese was chided by Justice Stevens, and deservedly so. But Mr. Meese needed only a new speechwriter, not a new theory. There happens to be enough doubt about whether the framers of the 14th Amendment intended to impose the Bill of Rights as constraints on the states. Enough doubt to sustain his questioning of incorporation, even if one took the essential 14th Amendment into account. Now, I believe there are grave, I believe insuperable difficulties with Mr. Meese's argument. Although some provisions of the Constitution are relatively exact in meaning, virtually all of the provisions on which the Supreme Court's important work in civil rights and civil liberties rest, such as the Due Process and Equal Protection Clauses of the 14th Amendment, or such as the provisions of the Bill of Rights, virtually all of these provisions are loosely written or even open-ended in textual meaning. And it is vital to recognize that all of the Bill of Rights and the post-Civil War amendments were fashioned by Congresses preoccupied with, to them, far more pressing matters than to tease precise meaning out of constitutional language that was typically and intentionally cast in indeterminate terms to paper over differences and encourage compromise. These open-ended provisions then went to the various state legislatures for ratification, a process that went forward on many fronts, again typically without recorded debate or careful attention to precise meaning. Moreover, and perhaps most important, even at the time of the Bill of Rights, but certainly and especially by the time of the post-Civil War amendments, the idea of constitutional provisions as broadly worded, organic conceptions capable of growth and intended to recur again to John Marshall, to endure for ages to come, this basic organic idea of constitutionalism was well established. The most distinguished opponent of Mr. Meese's positions, who has yet come forward, has been Mr. Justice William J. Brennan, Jr., and he has offered a radically different view. Justice Brennan's vision of the Constitution is cast not in terms of textual directives, but rather, to quote him, the aspiration to social justice, brotherhood, and human dignity, the lodestar for our aspirations, close quote. As he says, the Constitution's, and I'm quoting again, majestic generalities and enabling pronouncements are both luminous and obscure. And he insists that it is this ambiguity which necessitates interpretation. But as I read Mr. Justice Brennan, His notion of constitutional interpretation seems to me, at critical points, to be entirely uprooted from history, at least from original intent, which Justice Brennan derides as, quote, little more than arrogance cloaked as humility, close quote, because, as he sees it, in many cases we simply cannot know what the intent of the framers was. But for Justice Brennan, it is not only the opaqueness of history that propels him away from original intent as a foundation for interpretation. The passage of time alone, he argues, and I quote, cannot but work as a prism, refracting all we perceive. For the genius of the Constitution, I continue to quote him, rests not in any static meaning it might have had in a world that is dead and gone, but in the adaptability of its great principles to cope with current problems and current needs. And beyond that, he goes on, interpretation must account for the transformative purpose of the text. Our Constitution was not intended to preserve a pre-existing society, but to make a new one, to put in place new principles that the prior community had not sufficiently recognized, close quote. Now, we may readily agree that Justice Brennan's magnanimous conception of the Constitution is much closer to John Marshall's wisdom than is the Attorney General. But the problem, I put it to you, with Justice Brennan's response to the Attorney General is that he fails to meet the Attorney General's charge that constitutional judging in the Brennan mode is little more than subjective predilection cast in legal terms, and as such cannot be squared with the theory of democracy. The sweep of Justice Brennan's answer will, I fear, tend to reinforce those like Mr. Meese who believe that if the court is not tightly tethered to a constrained and concrete version of original intent, that then the alternative is unfettered judicial discretion. I ask us to consider whether the Supreme Court is left with such a stark choice in its obligation to interpret the Constitution between asking of the Constitution what it plainly cannot offer, the kind of tight, exact, original meaning that the Attorney General is enamored of, or failing that, must the court cut itself loose from the sort of interpretive connection to an authoritative text that I believe has always been the basis for our nation's deep-seated belief that constitutional law is a body of law, strictly speaking, and not just a pretentious gaggle of political pronouncements. If there is one thesis, point of view, that I hope I would impress on you this evening, it is this: that a very considerable avenue of escape from the dilemma I just described lies in an appropriately sophisticated understanding of history in relation to the constitutional text. The history that informs most constitutional provisions and that adds up to what we call original intent is neither as simple as Mr. Meese likes to claim, nor, I believe, as dead and gone as Justice Brennan seems to suggest. History is not so simple, and it is not so static. I would like to try to illustrate this claim by offering you 3 concrete examples drawn from major constitutional controversies still with us or of recent memory, examples which show both the necessity and the shining light that history can cast on our most crucial problems of constitutional interpretation. In the Watergate debacle, a great constitutional debate, you will remember, centered on the permissible grounds for impeaching and removing a president. At first blush, the text, you heard it earlier tonight, if you still remember it, at first blush, the text seems clear. Article 2 permits impeachment and removal of a president for treason, bribery, or other high crimes and misdemeanors. Now, if you have not entirely repressed this unhappy episode in our history, you will recall that Mr. Nixon's lawyers contended that impeachment was permitted by Article 2 only for acts that were criminal in nature. I will not comment on how protective such a theory would actually have been for the president. But of course, the point I want to make is that the terminology of Article 2 seems plainly, the text seems plainly to support Mr. Nixon's claim. But history casts an entirely different light. The words high crimes and misdemeanors, I do not have to tell you, sir, were lifted bodily from English law, where they had been routinely used for centuries to describe a wide variety of conduct for which Parliament removed, and indeed punished, executive and judicial officers. Many of the best known of these English impeachment precedents were based on official conduct, not remotely criminal in nature, but rather amounting, in Parliament's view at the time, to gross failures to carry out legislative or other governmental obligations. The English practice of impeachment for, quote, high crimes and misdemeanors was never predicated on criminal acts. High misdemeanor was actually used as a catch-all term covering serious political abuses of various kinds, used only in parliamentary impeachment proceedings and not having roots in normal English criminal law. If one looked more closely at the history of the impeachment provisions of Article 2, if one looked at the discussions, for example, so far as we have them reported at the Constitutional Convention, one sees that Randolph, for example, spoke of the need to impeach a president for abusing his power in connection with the public purse or the military. And Franklin argued that impeachment was necessary to prevent the drastic remedy of assassination, where a president had, quote, rendered himself obnoxious, close quote. Madison's notes report that he thought it, and I quote, indispensable that some provision should be made for defending the community against the incapacity, negligence, or perfidy of the chief magistrate, close quote. The framers did not discuss impeachment and removal as predicated only on instances of criminal conduct by a president or other officials. They saw it, as indeed any sensible person, I believe, must see it as a matter of public policy, as an appropriate and necessary response to many conceivable non-criminal abuses of official power or negligence of responsibility. So here is an instance where the text's seeming precise and concrete meaning is, I would argue, conclusively demonstrated by history to be different. And so indeed, it was, well, as you know, the issue was ultimately mooted by Mr. Nixon's resignation. But it was plainly the view of the House that the terms of Article 2, high crimes and misdemeanors, were not restricted to criminal conduct only, as Mr. Nixon's lawyers asserted. Let me offer a second example, one where the guiding light of history is both acutely subtle but also crucial to a constitutional right, to the correct or proper interpretation of a constitutional right, that I suspect many of us would rank as the most important of all the human liberties protected by the Bill of Rights. I refer to the freedoms of speech and press protected from abridgment by the First Amendment, and particularly to the central question about them. How far do they protect the right to criticize government or its officials? Now, the central historical question about this issue is whether the First Amendment embraced the received 18th century legal tradition of English law respecting speech and press as that law had been received, reshaped, renewed in the colonial, revolutionary, and formative periods in America. How far did the amendment embrace that tradition? Or, on the other hand, was it intended as a break with it, as a repudiation of the colonial, the English law, adapted colonial tradition? Now, this question of the embrace of English law or the repudiation of it in the First Amendment generally tends to be focused, if you will pardon a little technical legal talk, on the treatment of seditious libel. Seditious libel, very briefly, was an evolving body of English common law that held that criticism of government or of officialdom constituted a serious crime. The premise of the law was that such criticism carried in it the seeds of disorder, disobedience to law, or even revolution. Now, of course, if such criticism is viewed as so dangerous, then truthful criticism must be regarded as particularly lethal. And so the English common law saw it, followed this line of reasoning with a ruthless logic. Thus the old common law adage, and some of you may have heard and wondered about, the greater the truth, the greater the libel. Now, did the First Amendment embrace the law of seditious libel or repudiate it as a matter of the original understanding of the framers? This question has for a half a century at least engaged the energies of some of our most distinguished historians, and they have put the question in all or nothing, reception or rejection terms. Now, when you put a question of some complexity of this sort in these all or nothing terms, it's not too surprising that the historical interpretations we have had have fallen out along dialectical lines. Some historians have insisted that seditious libel was rejected by the First Amendment, and other historians with equal energy and considerable support in the historical record have insisted that seditious libel was in fact embraced by the First Amendment, at least at the time that it was drafted. What are we to make of this particular historical controversy? What the historians, I say with all respect, sir, I am not one, seem to me to have missed largely about this question is that the law of seditious libel in England, and especially in the colonies, was in a state of large and growing tension and flux throughout the 18th century. Tension and flux with respect to its basic doctrinal character, with respect to the crucial question of the allocation of functions between judge and jury, and with respect to the premises of the law in political theory. Very briefly, let me give you a sense of this flux. As early as the 1720s, Cato's letters, so-called, what I understand to have been the most popular and esteemed source of political ideas in the colonial period, Cato's letters had made an eloquent plea for the necessity, at least, of a freedom to tell the truth about the administration of government. The great lawyer Andrew Hamilton, of course, picked up this plea in 1735 when he insisted on behalf of the printer Zenger that, and I quote, "truth ought to govern the whole affair of libels." I could go on with further examples of the growing awareness and commitment to the notion of a defense of truth. Now, the historians have not given this emerging defense much credit, it seems to me. They have said, well, if truth emerged as a defense to seditious libel, the basic crime was still in place. And maybe it is true that in the Zenger case, and indeed in many others, juries refused to return guilty verdicts in seditious libel cases. And indeed, maybe it is true that the emergence in the 18th centuries of the power of juries generally as instruments of nullification in law, maybe it is true that that negated the operative social effects of seditious libel, but still, it was a law on the books, as it were, in the common law sense, and no one of the framers of the First Amendment, including Madison, who wrote it, not anyone in the House or the Senate, which passed the amendment and presented it to the states, and no one, so far as we know from the historical record, in any of the state ratifying conventions, said in so many words and clearly in 1791, before 1791, that the First Amendment repudiates the law of seditious libel. And it's on that account, basically, that the historical version of this problem that is now, I think, the prevailing one, put forward by Leonard Levy, among others, is that if one views the First Amendment in terms of original intent, it embraced rather than repudiated the law of seditious libel. This is quite a problem, let me tell you, for the First Amendment, because the political philosophers of freedom of expression are generally agreed that the central and most critical aspect of freedom of expression is the right to criticize government. If seditious libel is permitted by the First Amendment, we do not have that right, at least if we are true to our original intent. What is one to make of this history? To me, even assuming that the First Amendment was not understood to repudiate seditious libel, assuming some kind of an embrace of it, what was it that was embraced? What was embraced was, I would put to you in historical terms, a bird on the wing. We began the 18th century with a tough and uncompromising law of seditious libel that said criticism of government is a serious crime and the worse for you if the criticism is true. We emerged toward the end of the century with a law of seditious libel in which truth is accepted as a defense and in which juries are routinely nullifying efforts to prosecute. What does that add up to? It adds up to quite a lot, I would claim. In the first place, what it means to say that there is a defense of truth, don't think of this in technical terms, what that means is the emergence of a limited but important positive value for criticism, at least truthful criticism, that predominates, that trumps, if you will, the government's claim that criticism of the administration of the state is inherently dangerous and potentially leads to rebellion. One has a positive conception, if you will, of expression that emerges. And it's plain that this emergence is not a one-time only occasion, but the result of a vast historical interplay of forces with respect to seditious libel that see new value in speech about government, that identify such speech for the first time as a basic human right, that sees the role of the jury in what we lawyers would call interposition terms with respect to the power of the state, and that is ultimately fueled by Whig notions of popular sovereignty that represent the emergence of an entirely new conception of the relation of the people and the state. If the First Amendment embraces this, I say to you, it embraces not a static body of law which is, I think, the essential conception of Leonard Levy and the other historians, but as I said before, a bird on the wing. And in constitutional terms, in Marshall's terms, if one embraces a bird on the wing, the trajectory is much more important than the shape or even position of the bird at any one time. To put it another way, what the original intent tells us, I would say, about seditious libel, taking even a conservative view of the historical evidence, is that the framers operated with a principle of freedom of expression that was in rapid motion. And that, so that when Madison and when the First Congress embodied in the First Amendment of the Bill of Rights this principle of freedom of speech and freedom of the press, I believe it is fair to say from history that these supremely conscious human beings understood that they were putting in the Constitution a principle capable of growth, a principle that was in motion at the time they embraced it, a principle that would, in the fullness of time, and with a little assist from the Supreme Court, give us a right of political criticism that is as great as any that has ever existed that I know of in the history of the world, and indeed is, I would argue, the centerpiece in our system of all our constitutional liberties. History, again, here to me, in First Amendment, in this area of the First Amendment, is not something to shy away from because of the ambiguities about seditious libel. We can embrace it if we will understand it, and if we will understand that history is not a motionless, static conception, but with respect to most important things, a matter very much in flux. Well, I have a concluding example. I'm not going to work it through because I want to get to the questions, and I'm sure you do too. But I will tell you that my concluding example is I chose because it's different from the first two in the following way. The first was an example of a seemingly clear and concrete text, which, when the light of history is turned on it, reveals a meaning that seems inconsistent with at least the surface of the text, what one would read at first blush. My second example, an example in which history suggests the momentum of constitutional principles, the fact that they tend to be ideas in flux, that they are principles that are in their historical roots latitudinarian and capable of growth. Indeed, I would argue of the First Amendment and the right to criticize government that the growth of that principle could not have been stopped. So great was the historical momentum behind its development. My third example, I'll just summarize, concerns what I believe is the most important constitutional problem in general that has come before the Supreme Court since the Civil War, namely the meaning of the 14th Amendment with respect to our long and evil tradition of racism. Here, one has an amendment that is general, extremely general in its terms, using phrases like the equal protection of the laws, an amendment that is passed by a House and a Senate in which many of the, not all, many of the leaders of the amending process assure their anxious colleagues that the passage into the Constitution of these general provisions will not mean they need not worry that blacks would be invited to serve on juries, or that public schools would be integrated, but rather that this general language should be restricted to a very narrow definition of rights. And it is this history that one reads in the congressional record that is behind the claims of Raoul Berger currently, and many critics of the great race decisions of the Warren Court, who urge that Brown against the school board and the other great decisions were in fact antithetical, inconsistent to the historical meaning of the Equal Protection Clause. Well, what I would urge about this is that a true probing historical analysis of the legal background of the 14th Amendment, its derivations from civil rights statutes that began with the great statutes setting up the Freedmen's Bureau and ran through the various Civil Rights Act, would in fact show an evolution of legal language toward a more and more general conception of protection for blacks, a more and more general conception of racial justice. And I would argue that the history, in fact, belies the limited statements made on the floor of the House and the Senate by the supporters and indeed the opponents of the 13th, 14th, and 15th Amendments, and that the general language of these clauses ultimately should lead us to reject a narrow view of the history which gave rise to them, and instead to interpret them with respect to the full breadth of the generalizations implicit in the constitutional text. What one finds, in short, is a situation after the Civil War in which the various parties supporting the need for post-Civil War amendments found it impossible to reach agreement on specific, concrete applications of racial justice, and so instead agreed to put into our Constitution broad, vaguely worded, open-ended legal texts, texts that would be capable of growth, texts for which normative meaning could be generated by successive decisions over the years of the Supreme Court, texts, the promises of racial justice in which could lie fallow for almost a century, but texts which would eventually, and in the fullness of time, provide the basis for the revolution in race relations that is, I think, the greatest achievement of modern constitutionalism. Sir, my purpose in running through these three examples has been dual. One has been to show the impossibility of accurate and legitimate constitutional interpretation without constant and sophisticated attention to the lessons of history. And second, to show the impossibility, or inappropriateness at least, of constitutional interpretation that rests on history alone without appropriate attention to the fullness and the expansive potential of the constitutional texts our framers have given us. I must say that I can think of no better lesson that we as a constitutional people should remind ourselves of in our bicentennial year that with respect to our Constitution, as with respect to all aspects of our lives, we are creatures of history. And indeed, I would argue that our capacity to meet our modern responsibilities to adapt to the various crises of human affairs and to our own individual situation, our capacity to do that, to in effect escape and grow out of our history, depends ultimately on our understanding of it with respect to the Constitution and with respect to everything else that I can think of. Thank you very much. I look forward to your questions.
As the moderator, I reserve the prerogative of making a few comments and possibly asking one or two questions myself before we turn to the audience. I am sure that we got just what we expected, an illuminating, perceptive, and certainly persuasive analysis of the Constitution. I might say, in connection with the 14th Amendment and the evolution out of bondage into freedom, you can find no better account than in Professor Schmidt's part of the Bickel and Schmidt history of the Oliver Wendell Holmes device, which is a marvelous analysis of the evolution of the doctrine of the Civil War revolutionary amendments. Now, I should like to take a word as an historian on this question of intent. And I would like to stress something that most people have not talked about, and that is the great silences. The great silences. We all talk about the Constitutional Convention as if we knew what went on. The fact of the matter is that James Madison, a very scholarly and earnest chap, took a seat close to the president's chair, attended every single day, and made partly stenographic notes and also got copies of speeches and so forth. He went home at night, then he summarized all these talks. Now, there are also other versions of the Constitutional Convention, 7 or 8 other versions which are known. A few more versions have been turned up and will be published in a 4th volume supplementing Farron's Records of the Constitutional Convention by the Yale University Press, by the way, which are also illuminating. The point, however, is that if you read Madison's account of, say, any day of the Constitutional Convention, it might be June the 17th and so forth, you realize that with such a verbal group there, he was not recording not even 10% of what went on. If we had tape recorded these interviews, it would have been impossible for one man in an evening to have copied. It would take a typist to transcribe it. Each day would take a typist almost a week. So that there are great silences. And among the silences, or just to give you an illustration of the problem, one of the main reasons for the calling of the Constitution was, of course, to give the new federal government the power to tax. And one of the powers that are enumerated is the power to levy direct taxes. The word direct taxes is not defined. Some poor delegate got up and said, "What are direct taxes?" Nobody answered, you see. Of course, the assumption was that they were poll taxes and land taxes, but when the carriage tax came up a few years later, the Supreme Court said, now that's a direct tax. It doesn't have to be levied in accordance with the elaborate formula laid down. However, in the post-Civil War period, when the income tax issue came up, the 2 Supreme Court decisions were quite one reverse of the other, and it led finally to a constitutional amendment to settle what should have been a very simple question. The other reason, and probably the initial reason for the calling of the Constitutional Convention, was the Annapolis Convention, which took place in 1786 in which it was decided to enlarge the powers of the federal government over commerce. What is commerce? Commerce probably in those days meant trade. In modern times, the courts have defined it to include manufactures, much broadly, in other words, than was probably construed in the dictionaries in those particular years. It is given power to regulate commerce among the states. Does among the states mean between the states or within the states? Well, the courts have held, of course, beginning with the Gibbons and Ogden, that it meant between the states, but also in connection with railroads and so forth. It can mean within the states. And we know that obviously there are a whole series of phrases of this kind, the meanings of which were never clear even to the founding fathers. They were hopeful that many of these issues would be settled by precedent, either of presidential action or legislative enactment or a judicial decision in the course of time, and not necessarily delay resolution by the courts of these points. But these great silences speak for themselves, it seems to me, and indicate the impossibility in many matters of determining just what the founding fathers precisely meant in many of the basic terms. Would you care to answer that?
Well, I agree with that very much. I think that the open-endedness of many constitutional provisions is a result of I suppose it's one of the political truths that makes social life possible, and that is what you cannot decide today, you must postpone one way or another for a future time and let your posterity worry about it. And in one of the constitutional versions of that, well, you can see one version of that in the provision in Article 3 that was read about the inferior federal courts. They couldn't agree about whether there should be inferior federal courts, very dangerous instrumentalities, by the way, the lower federal courts in terms of state sovereignty, so they left it to future Congresses. But a more typical way was to formulate broad principles, whether the regulation of commerce, whether the meaning of equal protection, and leave it to the courts to slowly work out on a case-by-case basis with decisions that could be tested by experience and criticism and so on before other decisions would be added on. And the Constitution is filled with these principles where I would argue, sir, there is an intention, but the intention is to leave a concrete meaning to a later day.
That raises one more question, and my last, and that is, we criticize the public for its ignorance of the Constitution. We even criticize some of our leaders for either ignoring the Constitution or subverting the Constitution. But the answer is, we look to the courts for some kind of clear opinion about what the Constitution is. And I want to give you one example of what seems to me as a layman a difficulty. This comes from a fairly recent case involving the search of a high school student's purse and locker for cigarettes and marijuana. Took place in New Jersey. And this is the way that the decision of the court was rendered. White justice delivered the opinion of the court, in which Berger, Chief Justice, and Powell, Rehnquist, and O'Connor justices joined. Powell, Justice, filed a concurring opinion in which O'Connor joined. Blackmun, Justice, filed an opinion concurring in the judgment. Brennan, Justice, filed an opinion concurring in part and dissenting in part, in which Marshall, Justice, joined. Stevens, Justice, filed an opinion concurring in part and dissenting in part, in which Marshall, Justice, joined, and in part of which Brennan, Justice, joined. What can we do?
It sounds like a Yale College faculty meeting.
That's a new legal reason. I think possibly are there questions from the audience which are being written down? Are there instructions about that? Or there were cards to be distributed? Yeah. Oh, they've been brought up yet? Oh, I'm sorry.
I'll ask you a quick question while we wait for the question. As the country's perhaps greatest historian of the formative period of the Constitution, what grade would you give the Supreme Court overall as an interpreter of history?
Well, it all depends on which Supreme Court.
Well,
Now, for example, in the Marshall Supreme Court, we had very, very few dissents. When Marshall, we only had, generally speaking, we just had one opinion, and there was an occasional dissenter. When Marshall dissented, he generally did not record that fact. That was a great court.
he didn't let anyone else record it either.
He didn't let anyone else record it either.
He didn't believe in the First Amendment.
But somehow or other we knew the law. But I think we've had some great courts. I think that I think you would agree that the history of the courts represents a very uneven performance, and that the quality of the judges in the history of the High Court has been unusually high, but also there have been some mediocre ones and some difficult and some very difficult judges. But by and large, the third branch stands up quite well against the presidency and the Congress. That would be my Oh, here we are. The incumbent president has spoken about having an item veto. What is your view on such a prospect?
My view is that an item veto is inconsistent with our tradition. Part of the balance, the separation and sharing of powers between Congress and the president, of course, resides in the president's participation in the legislative process through the veto. But I do not understand the president's veto power to constitute a kind of open-ended power to revise and amend legislation that is sent to him for his signature. And the item veto, which is to veto this paragraph and not the other, is in principle to me a power to reshape legislation. That's not to me what the veto power is. But I quickly add this is not one of the areas in which I regard myself as knowing very much worth knowing. But
how might one address the historical inequities in the past and present treatment of ethnic, racial minorities in this country? Specifically, please address the constitutionality of educational or employment quotas and the use of constitutional amendments to correct social inequities. Can one have a time-limited amendment to redress this in some manner this year?
I think the chances of such an amendment this year are not great. They're too busy worrying about the balanced budget amendment or other constitutional fantasies. Well, this is a question that we could spend a month on and not get to the bottom. I would only say that it seems to me, as I said in my talk, that the greatest achievement of modern constitutionalism has been the achievement essentially of the Warren Court in at long last and belatedly respecting the promises of racial justice that were always inherent in the broad and general language of the 14th Amendment and the 13th and 15th Amendments as well. I would only say a couple of things about the present and the future. The court cannot begin to do this job by itself. The court has to depend in rooting out racial injustice, and particularly in discrimination that takes place not on the surface of state statutes, but in the administration of law, in the voting booths, through violence and intimidation. The court has to depend, we have to depend, on an active and vigorous executive branch, and also on a Congress that will provide the statutory basis for rooting out discrimination. One of our problems, I think, in our approach to the Constitution is that we expect the courts to solve all our constitutional problems. And we forget that it is to Congress and to the executive, for example, that Thaddeus Stevens looked to bring out the promise of the 14th Amendment. I think much of the obstacles to progress since the Civil War and continuing have been in the reluctance at times of Congress and particularly the executive. And I don't single out this chief executive, but it was true of Eisenhower. It's been true of many of our greatest presidents in this century. They've been reluctant to tackle the huge problems of racial discrimination in our society. I do not myself regard, well, the issue of quotas is an extremely complicated one. Let me just say that I do not regard the Constitution, the 14th Amendment is the relevant provision here, the Equal Protection Clause. I do not regard the 14th Amendment as an obstacle to the use of quotas, which I don't happen to favor in most circumstances, but I don't regard the 14th Amendment as an obstacle to the use of quotas because, again, to recur to the original historical context, much of the activity of the Freedmen's Bureau was directed at advantaging blacks and solely blacks, and of course that was understandable at the time, and I think it would have seemed ludicrous to the framers of the 14th Amendment to say that Congress and the executive should, in the effort to redress the centuries of racial deprivation, that they should not be able to single out the victims for special compensatory treatment. Now, in our time, the problem, I believe, assumes a different, more complicated set of dimensions. Yep. But I wouldn't hold us back. I don't regard the Constitution as holding us back from making whatever affirmative, compensatory responses to racism and to other forms of discrimination, gender discrimination.
Yes, well, that's why I was going to raise that question. I mean, isn't there enough in the 14th Amendment to take care of gender discrimination, where the court has ducked that?
Well, I would argue that, yes, that there is enough. The Equal Protection Clause, after all, is not framed in terms of race. Mm-hmm. It is a general guarantee of equal protection of the laws to all persons. And indeed, the court has not hesitated to apply it as a guarantee against discrimination for other than racial minorities, religious minorities, for example, religious groups, and indeed gender groups. I think what happened to the growth in the area of gender discrimination is that a lot of the steam went out of that when the Equal Rights Amendment failed. And I think the court, some members of the court, took from that kind of message that the constitutional politics of the situation had been tested and that the country had not been prepared to embrace a very strong anti-discrimination provision in the area of gender discrimination. I wouldn't have taken that message. I don't think it's right to view the failure of an amendment that way. It's so hard to get an amendment through, but I think that's what happened.
Now we have one that sounds as if it's been written by Justice Scalia. What do you see as the role of the Justice Department and other bureaucratic agencies outside the courts in shaping and articulating our constitutional rights. As I understand,
a huge role.
That as I understand, Justice Scalia is suggesting that certain cases, possibly involving, I'm not quite sure, Social Security or Medicare or things, be handled by administrative courts and not come into the federal judicial system.
Well, there is a strong move which is going to gather momentum and increase in force to remove many cases from the federal courts. The federal courts, I believe, are in fact badly overloaded, and I would myself support such a paring down of their jurisdiction to essentials. I would only say that I think our history since the Civil War shows I could almost argue, I think, that executive activity is more important than judicial activity in promoting civil rights. Many of our most important civil rights historically have concerned freedom from racially directed violence. That's simply not, that is a matter for federal prosecution. And in the absence of a very strong and vigorous executive branch Justice Department move against that, which we really didn't have until the late 50s at the earliest, in the absence of that, as we know, an absolutely appalling level of racial violence existed in large parts of this country, a level of racial violence that was, I believe, the essential foundation of the racial subjugation that was the actual fact in many parts of this great country, including the part that I come from. Now, it was the Justice Department that turned that around. I think it was the Warren Court that led them in a moral sense and by example, but it was the Justice Department that turned that around. It's so we. This is beginning to sound like a civics lesson. I apologize. It's just as important to remember and to be concerned about our Constitution when you vote as it is when you fulminate against the latest appointment to whatever court you care about. And I think we don't do that. We don't understand that sufficiently.
This is a question, maybe I can answer this one. Why were the first 10 amendments not included in the original Constitution? Well, in the first place, maybe that's why the Constitution was adopted in less than 4 months. But it's very clear that the Federalists, and certainly the High Federalists, believed not in spelling out rights in the Constitution. It was their theory, as is expressed in the Federalist on several occasions, that these rights were inherent in the people, and if you enumerate some rights, you might be excluding other rights. But this was a piece of bad judgment, because of almost every single ratifying convention held in the states urged amendments to the Constitution and urged the Bill of Rights. And the only way that New York State managed to ratify the Constitution, by a close vote, by the way, of 30 to 28, was by agreeing to a second convention which would include a Bill of Rights. Fortunately, Congress and Madison jumped the gun and passed the Bill of Rights through very quickly, and there never was a second convention, and I hope there never will be. But now,
I would just add that it was Madison, who was one of the strongest opponents of the Bill of Rights, who eventually drafted the Bill of Rights, which just shows that you got to be able to change your mind.
Now, Benno, this is for you. Do you agree with Forrest McDonald that the government of the, this is quote, that the government of the United States interferes on a level in ordinary people's lives that they, the founding fathers, would have regarded as the most vicious form of tyranny imaginable?
I agree with that completely on April 15th.
I might make a point, of course, that the whole New Deal is based upon Hamiltonian ideas of the welfare clause, necessary property clause, and so forth. And I'm not sure that the founding fathers would go along with Forrest McDonald which I assume is a quotation from his Nova Ordo Seclorum. I'm not sure where it comes from. This is a good one. This is for you. Can the Constitution be repealed?
Well, it gets back to that second constitutional convention that you were just talking about, doesn't it?
Yeah, well, let me ask you this.
May I just remind this group that the first constitutional convention that we're celebrating in Philadelphia in 1787 was a runaway convention. It was, in a way, a kind of bunch of outlaws in a constitutional sense. They were not brought to create a new constitution.
No, they were taught merely to revise and amend the Articles of Confederation.
That's right. They chucked the Articles of Confederation and ran away as a convention. They excluded the press and operated in secrecy so their perfidious designs would not be known. And because of this, we have the greatest act of constitutive lawmaking in the history of the world. And if it can happen once, it can happen again, and that's. But once is enough.
But they did, in a supplementary letter, which is not printed in the Constitution, in a supplementary letter issued the same day as the signing of the Constitution and signed by Washington, submit the Constitution to Congress and ask Congress to request the states to call ratifying conventions by vote of the people. And Congress, after 3 days of debate, did do that. So that gives the constitutional veneer to a revolutionary course.
A little after the fact ratification.
Right, that's right, after the fact. Decisions concerning constitutional issues refer to the appropriate historical background. That is, should decisions cite not only precedents, but historical narrative? I'm not sure that.
Well, yes, I think so to this extent. I think it is impossible to tell what most of the words in the Constitution mean that a court has to interpret, impossible, without knowing what those words meant in the historical context in which the framers used them. I mean, Holmes said it right when he said a word is the skin of a living thought, and you have to understand what's behind its skin. What are the living thoughts that give it meaning? Now, it's not a matter of, it's impossible to psychoanalyze the framers, and I'm talking about general social and intellectual context, not some psychoanalytical what was on Madison's mind when he wrote. That's impossible. But yes, I do believe, as I said, that an historical understanding of the authoritative text is always the foundation for interpretation. Interpretation goes beyond that as it considers precedents and current social realities and needs and public policy and many other things, but it always begins with that, I think. But a lot of people don't believe that. I think my view is a little more historically based probably than the most constitutional lawyers would say.
This may be something for Dworkin or one of the schools to answer. What, if any, support can be found within the Constitution to support the position that the government has an affirmative duty to ensure the equal distribution of resources and services, particularly those resources and services which are of a limited nature? And then apparently the affirmative regards this as the affirmative side of the First Amendment.
Well, that's a very big question, very important question.
Yes.
As a general matter, the conception of human rights in the Constitution is the conception prevalent, I think, in the Age of Enlightenment, which was a view that human freedom would eventuate if the government let you alone. And so freedom of speech or freedom of the press to the framers meant in general, whatever it meant, it was that the government should not interfere with you. And it would have seemed, I think, bizarre to Madison and Jefferson and the others to regard, say, freedom of expression as involving any affirmative obligation on the part of government to give the citizen a soapbox or a bullhorn or some other method or medium of expression. Current 20th century constitutional ideas, on the other hand, tend to embody the notion of human freedom as not only the result of negative restraints on government, but as the result of affirmative obligations on government to provide for basic human wants and needs, shelter, food, the minimum material standard of living that's necessary to dignity and the enjoyment of rights. That's a conception that our 18th century Constitution does not embrace. It is you mentioned the New Deal and the four freedoms of Roosevelt. It's a conception that has come into our constitutional order through the executive and the legislative branch, but not through the Supreme Court interpreting the constitutional text. My own view is that, for what it's worth, the great question that's facing us in the 3rd century of our Constitution will concern the problem of poverty in this country, the problem that a very large part of this country lacks the material and other essential human needs and wants that are necessary for things like freedom of speech, the right to vote, to be enjoyed in any full sense. And I think in our next 100 years, we'd better pay attention to Mr. Locke, who pointed us to the central role of property in the enjoyment of human rights, in writing in the 1690s. And I think we need a recurrence to our Lockean roots, but I don't believe it should be the court or the judicial process that should drive this concern. I think it should be our political process, and the fact that that in the last 10 years we've made whatever is the drastic opposite of progress with respect to that problem, I think should not make us pessimistic about the potentiality of our 3rd century to deal with it. But I think it is the central constitutional issue we will face.
We have a last question. I've been given the strictest orders that all lights go out at 10 o'clock and everybody must rapidly rush to the exits. But in any event...
Otherwise, we have involuntary servitude
in the
audience.
Well, the only good audience is a captive audience. Anyhow, you know that as a teacher. All right. No.
I never address any other kind.
This question involves, seems to be fairly recent litigation, free speech versus an individual's right to a good name. In what content, if any, would you sanction a private suit for libel by a political figure? Should the right to free speech entirely override the individual's right not to be disgraced by fallacious and damaging accusations?
I would sanction right of defamation by a political figure, certainly with respect to defamation touching on the political figure's private life, that is, not the political figure's official duties. But I think that our very recent history, and I'm thinking of the Westmoreland and the Sharon cases, illustrate to me, at least to my satisfaction, that when the press criticizes government leaders who are at the apex of their respective government situations, and as to whom criticism, with respect to their official duties, not with respect to their non-official lives, and I know that's a hard line to draw, but I think it can be drawn. When the criticism is with respect to their official duties, the personal defamation becomes so closely tied to criticism of government policy, and the issues of truth and falsity and assertions of fact and opinion and so on get so complicated, and the trial of those issues is so horribly expensive, and the capacities of juries to sort that out in some reasonable and credible way is, in my judgment, so limited that I've come to the conclusion that it would be better to do away with rights, with the law of defamation, so far as high officials are concerned when they're criticized with respect to their official capacities. And I say that as one who regarded the journalism involved in those two cases, Westmoreland and Sharon, as very sloppy indeed, and very at best. But I don't think freedom of the press can tolerate a situation in which a high government official, backed by contributions from some political groups or even a government, can force journalists and newspapers and whatnot into court, impose on them millions and millions of dollars just in litigation expense, and all the risk of the variability of juries, and we all know about that. I don't think that is consistent with what Madison had in mind when he said in response to the Sedition Act of 1798 that the central meaning of freedom of expression is the right to criticize public characters and measures. And he did not talk about that, Madison did not talk about that in a qualified way at that time. And I think we should not approach that in a qualified way at this time, even though the result will be the victimization of many public officials by an irresponsible press. That will surely be the result. But to me, the inhibition of criticism that is implicit in the capacity of the situations like the Westmoreland or Sharon cases is not tolerable in a society that relies as much as we do on freedom of the press.
Thanks for listening. For more information on the 92nd Street Y, New York, and all of our programs, please visit us at 92ny.org.